The broadcast is now starting. All attendees are in listen-only mode.
Well, hello and welcome to our second presentation of the NPMA's Asset Management Awareness Month. My name is Scott Ray and I am the Vice President of Seminars and Events. Happy to be here today and happy to have you join me on this call and very important and new information that'll be shared about the new DFARS GFP reporting clause. Before we begin, I just want to touch on a few housekeeping items. First of all, you will receive a continuing education credit for attending the webinar today. You can expect education credits to be applied to your profile within a month. So by April, you should start to see those show up. Additionally, the webinar today is being recorded and will be uploaded to our YouTube channel. So if there's anything you missed or anything you want to rewatch or listen to, it will be there also probably in the next couple weeks. There is a handout. So Tom was nice enough to send us a PDF of the slides that you will be about to see today. That handout is available in the handout section of GoToMeeting, so you're free to click on and download that information at your leisure. I think that is all that I had for today. So without further ado, I'd like to go ahead and welcome in Tom Ruckdaschel. Tom, thank you for agreeing to present. I'm excited to hear what you have to present today, and welcome in, and I will turn everything over to you.
Thank you, Scott, and thank you, Lisa. Good morning, if it's morning or afternoon, depending on where you are. It's noon my time here in Missouri. I'm going to go. I'm Tom Ruckdaschel. For those of you who don't know me, I'm an independent consultant, but I used to work for DoD, and I actually used to work for a contractor, and I've been doing this many years. Issues in property accountability and regulatory writing, and just about everything with the word property in it. So really happy to be here, and I'm glad I got the opportunity to present. I do want to say this is an hour. We're scheduled for an hour, but I will stay on as long as you want me to stay on. I got nothing to do. Be happy to do that. If anybody wants to call me at the end or email me, my email will be on the last slide. You can please do that. And I'll take any questions you have at the end of the briefing, because it just makes it easier for me to concentrate on the content a little bit, if you will. So the subject today is the new DFARS GFP reporting clause, and there's lots of moving parts to this. We got about 25 to 30 slides. I think I've covered the big things, and I hope this all flows, because I haven't really done this briefing on this topic before. I've done a couple of quick and dirty ones, but this is a little bit more. My target audience today is defense contractors dealing with government property. How many defense contractors out there with government property? Does anybody know? Probably don't. The last time I looked, there was over 20,000 and about 15,000 of small businesses. So there's a lot of contractors out there who have to deal with government properties. Government folks, of course, are welcome. Anybody is welcome. Non-government, NGOs, I don't care. Anybody, academia, anyone who wants to dial in is fine with me. This first slide, I've been showing this slide no matter what presentation I do, because there's a lot of new people who come and go, and people come and go and maybe don't know what a DFAR is. So I just want to cover this aspect of it. The FAR is the basic big government regulation governing the acquisition of goods and services. Most executive branch agencies use the FAR. There are exceptions. We don't have to go there today. The FAR is codified in Chapter 1 of Title 48, so there's a linkage to statutory requirements of the CFR. And what does the FAR do? It provides policy, tells contracting officers what to do, and it tells contractors what to do through various clauses. Example, -1. Included in the FAR is a good chapter to read occasionally. It's Part 1, which is the guiding principles of the federal acquisition system, because it tells you how this beast called the acquisition system is supposed to work. It's a nice chapter. I reread it occasionally. I encourage you all to do that. DoD, like many agencies, has authority to supplement the FAR, and they could do that for a lot of different reasons. It may be because there's some additional requirements that only DoD has to deal with and other agencies don't. It could be because of some specific statutory requirements. It could be some legal requirements. Could be any number of reasons, but DoD can supplement. Could be sometimes it's just to operationalize other clauses, and actually this clause is a good example of operationalizing -1. Then this is codified in Chapter 2 of Title 48. So DoD is Chapter 2. And similar to the FAR, it's DoD focused, and it's specific things for DoD, specific acquisition and contracting policy. Again, it provides basic policy, it directs contracting officers, tells contracting officers what to do, right? And it tells contractors what to do through the various clauses. Under the DFARS, there's this thing called PGI. I don't know if you've heard of it, but it means procedures, guidance, and information. Basically, that's the non-regulatory piece of the DFAR. Another way to look at it, it's just policy as opposed to regulatory. The -5 clause is now the new clause under the DFAR, and I'll tell you how we got there. So a little bit of background of the DFAR case. When DoD wants to create or modify a clause, they establish a case. This case happens to be number 2020 DO29. And like most of the clauses, changes, they put out a proposed rule back in April of 2000, thing is in my way here, 23. There's a 60-day public comment period. That's usually how it works. Sometimes it's less, but usually it's 60 days. And after receipt of public comments, a final rule is published, and this one was published on December 2023. And like anything new, it is applicable to new solicitations and contracts, effective 22 January. Somebody asked me recently, well, can the government grandfather this back into existing contracts? The answer is no. The contracts would have to be modified accordingly. There's some discussion about that, I understand, but this only applies going forward. A little bit of a misnomer when the FAR says new solicitations and contracts. New solicitations is really what it's all about. Existing contracts that have to be modified. But anyway, the key date there is January 22nd, 2024. So if you get a new solicitations, this will have, assuming everything works on that end, this clause would be included, or at least the requirements for it would be included. This clause applies to all government furnished property. There's no exceptions to it, really, that I've seen. There are special requirements for serially managed GFP. I'll get into that. Specifically in two areas. One is the incorporation of serially managed GFP into higher level assemblies, and a separate requirement for marking of reparables that are serially managed. Combines the data reporting requirements of DFAR clauses into a single clause. So if you remember, you had 2011 7007, which was reporting a GFP, and that went under like 2 or 3 different iterations over the years. Full confession, I was involved in those. 7002 and 4, one was reporting loss, and one 7004, which put in PCARs into a clause. Be aware that you're going to have old and new contracts. So you're going to have old contracts with these old clauses, and you're going to have new contracts with the new one. Talk about that a little later, but just be aware of that, and that can create some complications. There was another clause called 7001, which dealt with tagging, labeling, and marking. Didn't really operationally do much. Everybody was kind of tagging stuff anyway. It was a little unclear. It only applied to serially managed anyway, but that's gone. I'm kind of glad that one is gone. I thought it was a little bit of an anachronism at this point. But as I said, it has some new things, and the big one to me is the requirement to mark serially managed reparable items. That is a new requirement. Take note on that one, if anything else. Let me move to the next slide. So this is an excerpt. Did I spell that right? I hope so. Excerpt from the Federal Register notice of the final rule. What did the final rule do? Consolidated clauses, updated references to applications, et cetera, et cetera, et cetera. The nice paragraph on what it did. Unfortunately, it left a few things out, and that's what I'm going to cover today. But I can tell you the main issue for this reporting clause is PIEE, Procurement Integrated Enterprise Environment. If you don't have access to PIEE and you are operationally required to work this particular clause, then you need to go in and get a login and a password, so on and so forth. But everything you hear today is going to be about PIEE for the most part. So bottom line up front about this clause, everyone thinks it has to do with data reporting, and that's true, but there's really three different requirements. It's got the data reporting requirement, receipts, shipments, property loss, disposition, the incorporation of higher level serially managed GFP items, and transfers between contracts. I'm going to point out something here that's important for this presentation, and I'll go through it a little bit further as I go forward. You'll notice I put that in red, transfers between contracts. And here's why I did that. Receipts and shipments and property loss reporting and disposition and the others, those are contractor processes. Transfers between contracts is a government process. Contractors do not transfer between contracts. Only the government can do that. Only the CO can do that via contract mod. True contractors have to adjust their records if the government decides to do that, but that's obviously a different story. But be aware that that reporting requirement pertains to something the government has to do. And it always intrigued me why, now it's not a new requirement, that's been in the old clause too, the 7007, but it always intrigued me because if only the government can authorize it and only the government can do it, why does government rely on industry to report back to the government that which the government did? I filed that in my head as I don't get it. I still don't get it, and I probably won't get it, but that's what it says. I'll talk about that further down. There's also a marking requirement. That, in my opinion, is not a property management requirement. That is an embedded deliverable. It is an embedded deliverable for services. You need a contract line item to do that. If you don't have a line item to do it, you can't get paid, you can't do it. So there's things embedded in there. You got to assign a UII, which is a unique identity identifier. You got to mark and register the serially managed GFE replicable, etc. Again, that to me is an embedded deliverable for services and not a property management requirement. There's also a collateral requirement because it requires a couple of things associated with that. Let me get this little box out of my way. You got to search for technical drawings. I'll show you the language, don't worry. And you got to check the registry for items that were previously registered. That's work you got to do. I would think, and I'm not a contracting officer, I never have been. I do know a little bit about CLINs. That likely requires a sub-CLIN. To me, they are separate things, but related to the mark requirement. So I don't know how contracting officers are going to get the word that they got to do this, but if you don't see a CLIN, you can't do these things. Pregnant pause there, but that's what it says. Those are three different requirements. So let me continue here. My computer is not cooperating. A couple things you want to be aware of here. This is kind of hidden stuff that you're not going to know about unless somebody kind of tells you. The new clause 245-7005 is required in contracts containing the property clause -1. That's pretty clear. DFARS 245-107, which is the policy piece, which tells contracting officers when to use clauses. That's what it says. But there are exceptions to that, namely for Part 12 contracts, which is for commercial products and services. Some of those Part 12 contracts will not have -1 because, according to 45-107, the amount or the value of the GFP is less than the simplified acquisition threshold. Off the top of my head, I don't recall what the simplified acquisition threshold is. It used to be 250, 50,000. So you're going to see some FAR Part 12 repair service contracts awarded without the 7005 because their value is less than the SAT. Therefore, there will be no clause, no requirement. They won't apply. What to do about that? Probably nothing. I just want you to be aware of that. You may get into these contracts or solicitations and you're not going to see the clause. This law presumes that the government side knows what they're doing here and knows when clauses are applicable and not, but that's what the policy says. So, like a lot of my presentation today, be advised. So this is where it gets complicated. This is paragraph B3 of the clause, reporting to PIEE. This is all about data. Now, the first one you would think is easy, but it's not. It says receipts. It actually says report the receipt. I'm interpreting that as the acknowledgement or the reporting of something that has already taken place, namely the receiving action. I would say, since, and I'll get into this later, everything has to be done in 7 days. I would think report the receipt has to be done within 7 days of creating a receiving report, because that's the receiving event. I think some on the government side, I don't know this, I'm just trying to think like they think, which is this may be interpreted as being 7 days to create a receiving report. That's not what it says. It's 7 days to report the receiving event, which is something that's already occurred. So if you're doing receiving reports within whatever amount of days, that doesn't change anything. It's only reporting to PIE that the receipt occurred within 7 days. Shipments to the government or to a contractor, it's just shipments. I don't know why they really put that in parentheses. It could be anything, really. Disposition, which is reporting to plant clearance, which used to be called PCARS, but now it's the GFP module for plant clearance. Okay. No, that's the old 7002 clause, excuse me, 7004 clause. And something called what I call a consumption event. It requires contractors to report serially managed GFP that's incorporated into a higher level component. New requirement. You got to do that within 7 days. And I have an opinion about that as to what that really means. I would think that that incorporation into a higher level component it means a permanent incorporation into a higher level component, or at least not readily severable. I've got an extra asterisk here that I do not need, and I'm going to get rid of that. Whoops, sorry. Anyway, I'll fix that later. That is a new requirement, to be aware of that. It occurred to me when I read that if by chance the government did not mean something more permanent, and you took out and you incorporated something into a high level component, if you took it out later, would you have to report the fact that you took it out later? I don't know that. So I don't think they mean like a serially managed PC card that comes in and out, every 10 minutes while you're doing a test. I think it has to be something a little more substantial to that. So that's my take on the consumption event. Now, the last one in yellow is the one that gives me issues here. That's the transfer between contracts. And that's all it says. That's all the clause says, transfers between contracts. That's not defined. You have to figure it out as a contractor. And the only way to figure out what to do is to go into PIEE and noodle around, or at least go to the DoD procurement toolbox and take the training. But what it means is you have to update the GFP module using its transfer function whenever contracts are modified to incorporate, to add or delete GFP from one contract to another. Ideally, I would think that means after standard form 30, which is a contract mod. And this is the language from DFARS PGI, which says COs, contracting officers, will use a form 30 to execute a transfer between contracts. Note it also says no other forms or documents such as the 1149 are authorized. FYI here, so if you're still getting 1149s from COs, and we know they do, I would argue that you can't report until you get a mod. That's my take on that. So be aware of that requirement, that a contract mod is required. So a little bit more on this thing they call a transfer function, and this is kind of what puzzles me about it. Again, the only thing it says is transfers between contracts, but the GFP module itself has a transfer function. It's called a contract-to-contract transfer. You're not going to know that unless you go in and look around. But what it does is, and I got this right from the procurement toolbox, you can check, it acts as both the shipping document from the losing contract and the receipt for the gaining contract. Now, why DoD felt compelled to create this function, I don't know. Because I don't precisely understand why DoD would feel that is necessary. But what makes it interesting is, excuse me, the GFP module and this is a government record. And in this age of audit readiness and audit scrutiny, I don't know why DoD would want to rely on the manual entry of contractor employees of over 20,000 contractors, making them responsible to make this transaction. Because it is, the amount of variation is staggering. That grid will never be accurate. Aside from that, there's always been discussions over the years about should contractors be updating government records. I'm not going to get into that, but it just seems odd that the government would want to require industry to report this function, because it's really not. You'll see what they did here. They created a receipt. They reframed the phrase receipt to meaning adding to another contractor, and a shipping as deleting it from another contractor. Doesn't make, I don't get that. I think that's way too much, too complicated. But note that in order to do that, the contractor has to, this all has to be within the same cage. If it's a different cage, you can't do it. Again, so right away, you see the requirement to transfer property between contracts and report it is limited to the fact that it's all of the same cage. Now, here's my problem here is that the clause says nothing about this. You have to go and figure it out, and Lord forbid you get it wrong. So be aware of this transfer function, and be aware that it's got to be done in 7 days. Otherwise, you'll probably get a corrective action request. The bottom line here, you, the contractor, are now going to be evaluated on the ability to update a government record. And I just don't understand why that is necessary. So that's my provocative statement for today. I don't get this one. Maybe there's a reason. Maybe there is. Maybe there isn't. But it just seems unnecessary. Especially since it's only the government can transfer property between contracts. Now, reporting timeline, this applies to all the things I've just said. It's got to be done for within 7 calendar days, except for plant clearance reporting and property loss. So if you take 8 days, you're not in compliance. And that's what it says. I'm glad that they left out plant clearance reporting and property loss. That just goes back to the FAR requirement, so you have some discretion there. But everything else has to be done within 7 days. So here's the question I hear most often. I hear this from clients from time to time. Do I need to report as a receipt, contract required, delivered as GFP? Well, that would depend on how you define receipt, wouldn't it? The clause does not define receipt. So I would say, no, you don't have to. So if I was a first-year law student, learning that if a contract doesn't define a term, the common understanding prevails, I'd go to the common understanding of the term receipt, which is the act of taking physical possession. Delivery of cap, notice I put a TR there, that's my opinion. Doesn't mean anything, that's just that's my interpretation, good or bad. The delivery of cap is a contractual event, doesn't involve taking physical possession. So doesn't equate to the word receipt. I would say you don't have to report that. Food for thought, remember those ASTM standards? Get 2 definitions of receiving and receipt. The process of accepting, the acknowledgement of assets received. That to me is the most reasonable definitions of what the term receipt means. So, Tom's crystal ball. The coming year, we're going to see a large number of cars, and many of them will pertain to receipt, and many of them will return to transfer reporting. Most of that will be poor communication. Most of that will be differing interpretations of clause requirements. What to do about it? Well, I always try to provide advice. Now, there's not much you can do about the transfer thing, because that's strictly a DoD issue. But you can ensure your procedure defines receipt, i.e. the physical act of taking possession. You can ensure your procedure sufficiently addresses the process, the receiving process, the timelines. Some people call them process targets. I like that a lot better than timeline. So you have so many days to create a receiving report, so many days to manage discrepancies, and then the 7-day reporting to PIE. That makes sense to me. The worst that can happen is someone disagrees with you on the government side. Well, okay, that's a disagreement. You haven't done anything wrong. You haven't breached your contractual requirement. And I would say if you define receipt, then the burden of proof is on someone to say that that receipt definition doesn't make any sense or is wrong. But as I said, we've got 3 different definitions that are out there that you could use. So be aware, I think that's a possible solution to at least the receipt issue. Also include a process for subcontractor reporting, especially when the government drop ships GFP to your subcontractor. I would call that a receipt. I think DoD would too. So when you're looking at flow down requirements, think about that stuff. I mentioned cars, and I just want to, I like this definition. This comes right out of DCMA. A car will be issued against a valid contractual requirement where there's a clear departure from the requirement. Defining receipt, even if someone disagrees with it, is not a departure from a contractual requirement. I think you're allowed to define receipt. Just a little bit of possibilities for you to negotiate your way through the PMSA process. I'll stand by that one. And here's where the fun starts. Marking, reporting, and UII. This is paragraph D of the clause. These are the embedded deliverables. This is, to me, is a non-property requirement embedded within a property clause. Note the 7-day reporting timeline does not apply here. That only applies to paragraph B2, not paragraph D. Before I even talk about marking, I want to talk about the GFP attachment. Other things I hear all the time. You know, this is right from the DFARS. This is guidance to the contracting officer. It's actually direction to the contracting officer. Contracting officers create the attachment. They specify the GFP elements. They identify what's serially managed or not. They accomplish the electronic transmission to PIEE. Contractors do not create attachments. Contractors do not amend attachments. Contractors have no responsibility whatsoever for a GFP attachment. You don't even have to identify if one is missing or not. Well, you should, but this is a government responsibility. I want to make that absolutely clear. A little bit more about marking criteria. Now, for those of you who've been around a while, you'll know there's another clause called 2011-7003, which is really the production of new items. And that requires marking of deliverable items of equipment, $5,000 or more. $5,000 was, and I think still is, the DoD property accountability threshold. And then if it's under 5,000, there's some discretion. Program manager makes these decisions all the time about what they want marked. There could be all kinds of reasons to do that. One of which is serially managed items, but it's not required. But it's a possibility. There's also mentioned in that 7003 clause compliance with ISO standards 160.022 and 15459, and more importantly, the MIL standard 130. That talks, if anybody wants a copy, just email me and I'll send you one. But that's the standard that elaborates the DoD requirement on how to mark, when to mark, where to mark, etc. It's kind of an engineering document, but it's not a difficult read. Now, if you go to the 7005, which requires the marking of, well, I would say previously delivered items, reparable items that are serially managed, there is no dollar threshold. It does have to be identified as serially managed in the attachment. If it's not identified, you don't have to do it. Be aware of that. It seems odd that you would think if DoD wanted serially managed items marked, they would have just made it a requirement under 7003 and not rely on a trigger event, meaning the trigger event from 7005 is the thing is broken to do a mark. But anyway, that's what it says. Little issues there in red. I have timing. Now, I think this is going to be interpreted as, well, something comes in reparable, it's serially managed, I have to throw a tag on it upon receipt. That is not the requirement. That is not what it says, and I would advise against doing it. And let me explain why. A reparable item comes in, it's evaluated, inspected, goes through the induction process, et cetera, comes out the other end, and it may be uneconomical to repair. Why would you want to mark something that is going to end up in the scrapyard? So consider the timing and get with your engineering and your quality people to figure out at what point those, if you even can, mark or create an IUID for those items. The clause does not specify a time frame here, so you got to do it independently based on whatever industry requirements exist. You'll notice also in 7005, unlike 7003, a mark in accordance with what? Doesn't mention MIL standard 130. Doesn't say a thing about ISO standards. How do you do it? Well, I still think those ISO standards, the MIL standard 130 applies, but note that it is not, they are not mentioned in the 7005. They are just not. Nor does 7005 say anything about commercial items. Now, in my own view, DoD's never really come to terms with commercial items in marking. They just haven't. It is mentioned in MIL Standard 130 that it's optional, but I don't know really if DoD is really imposing marking requirements or IUIDing things on commercial items. I suspect they are not. I can't prove it. There's no data on that. But if you do get an item, a serially managed commercial item, which is theoretically possible, I guess, be aware that it may not make a lot of sense. And I don't know what else to say other than it may not make a lot of sense. Again, I think the marking issue is a quality issue, not a property management issue, therefore arguably not subject to a PMSA. That is my opinion. DCMA and the Army and Navy and the Air Force may disagree. But I don't see how it can be a property management requirement because it is a service, and services for CLINs are required here. My opinion here. Provocative stuff, I know. A little bit more about serially managed items. It's defined in the clause, been around, the definition's been around a long time. It's got to be designated by DoD. Simply having a serial number does not automatically mean an item is serially managed. A lot of people get that wrong. I always like to say, my toaster has a serial number. Doesn't mean it's serially managed. It's got to be identified by the contracting officer, by the attachment, and if you really want to get do the research, there is a DoD instruction on serially item management, which is 4150.19. I just put the picture there, and that sets forth the policy on how DoD comes to these kinds of decisions. There could be all sorts of reasons for making an item serially managed, but if it's not in the attachment, there's nothing you can do. Okay. Additional reference on IUID standards, if you're interested, 8320.04. But the big one here on the right is what I want to stress. I want to stress that if it's not identified in the attachment, then it's not serially managed. I digress. So, just generally speaking, in the clause, there's no requirement really to do anything differently for serially managed items unless you incorporate it into a higher level assembly, which is a reporting event, or the items for overhaul repair. In both cases, it's got to be identified in the attachment. Hate to keep stressing that, but it's true. If it's not so identified, there's no requirement. And nor is it your responsibility to check. You can, and maybe you should. You should always have the communications going on with your contracting officer. But be aware, if it's there, it's there. If it's not, it's not. This is right out of the clause language. Let's have a little bit of fun here. Now, this is what it says in D1. The contractor shall sign in the UII, mark the items. Okay. Identify serially managed in the attachment. Good. When the technical drawing is accessible to the contractor and the drawing includes the IOID data matrix location and marking method. So you got whens and ifs here. I'll do the when first. So first of all, I don't know why a technical drawing would have the IUID data matrix location and marking method. You would think it would automatically be assigned to UII if the drawing has that requirement. So I don't know why an item would come in and then without that, and then the drawing would not have, and then the drawing says it should. That kind of confuses me. But anyway, that word when is important there, because how do we define what is accessible to the contractor? Does that mean you got to look for you contractors out there? I think that's going to be interpreted as you got to look, you got to do the research, you got to find, you got to figure out if it's available. And frankly, if you're not the OEM, it's going to be hard getting that technical drawing. It's probably proprietary. So be aware of the when there, and then you have an if. You'll assign the UII if an item is found to be marked but not registered in the IUID registry. That means you contractors have to check. You have to look in the registry to see if it's already registered. That's work. And you got to consider that work when you're putting together your proposals, etc. So you got whens and ifs. So it's hidden requirements there you got to be aware of. More on marking and on these things. Are you the OEM? Are you the original equipment manufacturer? Do you have design authority? Are there any other engineering and other technical constraints? You know, one thing about marking
Tom,
anything, yes?
Tom, it's sorry. I'm sorry to interrupt you, but I have a laptop set up as a control, and it just said that GoToWebinar was experiencing technical difficulties. So, real quick, are some of you still out there? Are you able to? I haven't seen it log people off, but since mine
Okay.
went out, I want to make sure people are still here. Can somebody drop in the questions box? Okay, they're still here. Carry
Okay,
on.
good.
Sorry. Okay.
Okay.
Sorry about that.
So questions to ask relative to the serially managed part and marking and assigning UIIs. Are you the original equipment manufacturer? Do you have the authority to do that? Do you have any constraints? It's not simply putting a tag on something when it comes in. It's a little more technical than that. In my experience, the UIIing and the marking work very well in the Mill Standard 130. Works really well when you're manufacturing something. Gets kind of clumsy when you have an existing item and you got to reverse engineer it to market. Doesn't say that anywhere, but that's just the way this stuff reads. Are the items commercial? Again, back to Mill Standard 130. If you read that, it makes the marking of and the IUIDing of commercial items not a requirement, but open-ended. You could if you wanted to, but you don't have to. So just be aware that many commercial items just simply will have a commercial mark and not a government mark. These are things that I don't think government has worked through yet, and you need to be aware of these things. So commercial items is out there. I was teeing it up. It's a whole nother presentation. Just be aware of that. So a little bit more about the whens and ifs. This embedded research, I call it an embedded research process because it's got various little targets in there. So if you got to do this research, then your procedures must now address, was the research performed? Did you document the research? How long did it take? Where did you look? How was it done? Someone might say on the government side, well, your research wasn't adequate, or maybe it was. How are you going to demonstrate that? What's the due diligence on this? I don't know. Did you check the registry for an existing UII? When did you check? Did you document that you checked? When did the checking occur? How long did it take you? Who, what, when, where, timelines, key controls. You got to be aware of this stuff because if you're a government contractor and you're getting a PMSA, this is what you will have to address because that's what the clause says. Now, again, some of this stuff may be part of the property management system procedure, but I'm kind of thinking more of the quality systems at this point. The actual marking is definitely quality, but all this collateral stuff, I could go either way depending on how your company is structured. It's stuff to be aware of. Cleanse, all these things, these collateral things are services. When you're marking a piece of property, it's a service. Otherwise, you're not going to get paid. Are assigning, marking, researching, registering GFP considered service? I think so. Contract line items, what are they? Well, that's assigned to specific items or services listed within a contract. The delivery events. The separately identifiable services a person can identify and separate out. So it works for me. That's exactly what's going on here. You can also have some deliverable subline items. And I think some of the collateral functions I mentioned earlier would be considered deliverable subline items. Again, I'm not a CO, but that's what they got to do. Otherwise, this marking requirement falls apart unless you have contract line items. One little paragraph in the clause makes it pretty clear that the contract has to use wide area workflow to report the shipment of reparables and completion of the repair. That tells you right away there has to be a line item. So that's just a little bit more evidential paragraph there. DoD put out a line item guide back in April. Good document. Easy to find. Quick Google, you'll read it. Obviously, it's what the government has to do, not a contractor, but it does tell you how things should be. It has references, examples, explanations, context. Good job. They did it right. And if you read that, go through that line item guide, you'll see exactly, I think it supports what I'm saying about the delivery of services relevant to the marking requirement. Final thoughts. Pretty good, 40 minutes. If you're reading your contract, it's too late. I know we always give presentations and we say, read your contract. No, it's too late. Read your solicitation. let me explain why. Just a scenario. You, the contractor, get in a, sorry for the noise, somebody is mowing my lawn. You get in a contract to repair some items, serially managed items, right? And your estimators get in the solicitation, could be an RFP, could be an IFP, and they're going through the solicitation and for repairs, and they price it out, do the right thing, send it back with a proposal, and you get the award. And then you get the award, and then there's this new DFAR clause in there that talks to marking, which you probably didn't even know about because you didn't have, because it's a clause. It wasn't part of the provision, right? It wasn't part of the solicitation. It could be in theory, but they're not gonna know about that marking requirement in most cases, I think, when they're putting together a proposal. So read your solicitation and make sure your estimators are aware of this marking requirement that's embedded in the clause, because if they don't consider it, you're going to underbid, and then the contract gets awarded, and then you have all kinds of friction and disputes and the request for equitable adjustments and everything else. And you're allowed to do that. Just people forget FAR Part 15 language. You can exchange information. The government can exchange information with contractors on from the earliest identification of requirements to the receipt of proposal. So it's encouraged. So engage your contracting officer. When I say that, I don't mean simply picking up the phone. I mean on this whole clause and everything involved. Give them a plan. Give them the who, what, when, where, why, goals, milestones, dates. Tell them how you're going to implement this. That goes a long way to prevent I'll say PMSA kinds of problems, because when the PMSA comes in and you're getting written up, you're on the defensive. Be on the offensive. Brief it out. Tell them how you're going to do this. And if there's issues and confusion, the things that you don't understand that make it performance problematic, tell your CO. They can do one-time contract deviations. So it is possible. As we like to say, this is space that does not cooperate. So none of this is easy, but it is possible. And I think that was my last slide. That was a lot of information, I know, but only had 40 minutes. I tried to get as much in here as I can. But wait, there's more, but you have to come to RENA. We'll talk about this some more. I'm always doing additional research. And we have 15 minutes before the top of the hour, and I would be happy to take whatever questions you might have. I'll open it up here. If you want to take me off mute, I'll be good to go.
I have some questions coming in. So the first one,
Okay.
if a receipt has a ROD, does the 7-day time frame start once the ROD is resolved? And then there's follow-up. If the receipt doesn't list a contract number, does the receipt time frame start once the contract number is defined? Could this reasonably be defined as the receipt definition to delay the 7-day time frame and be acceptable?
That's a great question. Very well thought out. I'm not sure how DCMA would approach that. If the DCMA is looking at it, I would think you would not wait for the ROD to be resolved. That's first part. That could take a while. The second part, waiting for the contract number. No, I think you'd have a lot of explaining to do. I think you should report the receipt within 7 days. And granted, there's going to be you have potential for a lot of information not being available. It may be possible to delay it, but if you do, I would at least tell your CO about it. I guess it would depend on what's missing. So the clause doesn't specify those little variations, and there's a lot of variation out there. So I don't know if I answered your question. On the first part, I would not wait for the ROD to be resolved. That's easy. Report the receipt as best you can. Next question.
Someone dropped in a comment there. You need the contract number to acknowledge receipt.
Okay. Fair enough.
So, and then
Well, you could go back to the CO and ask, okay, I got this. There's no contract. What do you want me to report it under contracting office? See if they'll respond.
Okay. And then there's
I think that's better than just putting in any number, because then if you put the wrong number in, you'll get written up putting the wrong number. So put in the number that the government will agree with.
Okay. And then someone said, going back to reporting a transfer within 7 calendar days in PIEE, is this 7 days after contract end date?
No, in my opinion, it's 7 days after the contract mod.
Okay. Couple of housekeeping things. Yes, this webinar is being recorded. I know people are asking, I guess some people can't see the handouts. I will create a link and email it out to everybody in case some of you cannot get attachments, but I will send a link where you guys can download the presentation. Okay, let's see, where am I? Here's somebody, I did not quite understand the marking section. Somebody who wants to see if they, either if you've got time to respond now. Does this new clause imply that we now need to track the split? Sorry, coming in so fast and furiously.
Sure, I understand.
Oh, I'm sorry. This is a different section. Somebody wanted to know if they could stay on after to talk about the marking section.
I'll stay on as long as they want.
Okay. Kristen, if you can hang on, we'll get to back to that. Here's one. If a repair facility is tagging their repairs accordingly, but then splits a portion of the repair, does this new clause imply that we now need to track the split independently from the original larger item for repair?
I don't know what Jim meant by that one. I need more info. Well, first of all, you used the word tagging. So right away, I blinked. I wasn't sure what you meant by that.
Okay.
Can you rephrase that maybe?
Okay, Kelly, if you can rephrase it, I'll read that out again. Here's another one. If contracts that were created prior to 22 January 2024 were
Right.
MOD'd by the USG with the -7005 clause, and there is an active GFP associated to that contract, what do you suggest they do?
They being the contractor? Well, ideally, the government should not have done that unilaterally. I know. So I'm not sure why that would have happened. I guess if the government suddenly added that clause to an existing contract on its own, that would create all kinds of drama because you still have the old clauses. I'm not quite. Did that actually happen? If the government wants to modify the contract to include this requirement and then delete all the other clauses, I suppose they could do that bilaterally. You'd have to, as a contractor, agree to it because you have new requirements in there that you haven't even considered. For example, marking, for example. So you'd be creating a whole nother effort if you just arbitrarily accepted that clause. I hope you didn't. And that's one of the reasons I wanted to make this presentation is I think there are some who will go, oh yeah, we'll just modify the contract, get rid of the old clauses and add the new, but it's way more than that. It's way more complicated than that. So I advise clients not to do that.
Okay.
At least not unilaterally. At least not accepting it unilaterally.
Okay. Another question, will this be presented again before the NES?
I'm doing a similar presentation for my chapter North Texas. You can find the invite information on the North Texas LinkedIn page if you want to come and take part in that. And then I continue to modify these presentations as I go along in advance of the NES, and then the NES will be put a bow on this presentation because I keep thinking of different things to cover, different things to take out, different things to take in. Having said that, if you want to call me offline and brief your folks, I can do that too. Because I'm retired, I can do whatever.
I think that was Joe getting a plug for the North Texas chapter thing.
Oh,
So,
okay.
okay, Joe.
Oh, okay.
Thanks.
Hey, Joe.
But
Hi, Joe.
yeah, if you want time with Tom, come to the NES.
Yes.
All right, here's another one. If MDA wants us to receive an item on a transfer but has not provided a GFX list on the mod, what can we do to ensure that we have authority to properly receive the items?
Could you repeat that, please? I got to unpack that a little bit. Say that again.
I can. If MDA wants us to, and this is in quotes, receive an item on a transfer, but has not provided a GFX list on the mod, what can we do to ensure that we have the authority to properly receive the items?
So I wouldn't couch that in your authority to receive it. I would couch it in, do they have authority to provide it? So having said that, I think even though they haven't done it properly, they do in the grand scheme of things have the authority to provide it, and you should acknowledge the receipt in the GFP module accordingly in your records. So I don't think it's a matter of you having the authority to receive it. If the government sends you something, you got to receive it. Period. There's no question about that. Just as a general proposition, they're dropping it to you. You're now the steward of it. So you got to process that. You got to process that receipt. But you can go back to the CEO and say, hey, you're missing a whole bunch of things here. And in PIE, there is an application called CCR. I forget what it stands for, but it's a contract correction tool where the CEO can go back and make corrections to whoever is missing. In this case, it sounds like the exhibit is missing. Contract efficiency report. That's the phrase I wanted. So I hope that answers your question. It's not much you can do. It's not much you can do with, there's a lot of things the government has to do, and many times they don't. And you don't want to be the key control for the government either, but you just want to document what occurred. And in this case, you'd be hard pressed not to receive something that the government sent you. Okay. In my opinion.
Right. Another question. Does the reporting of receipt mean 7 days after we receive GFP at our site?
No, it means 7 days from the time you make a receiving report, in my opinion.
Okay. Another question. If there is a CLIN for 5 different tools, deliverables with different costs, then does the CLIN guide say to have 5 subline item numbers?
There are examples of that in the guide. I would have to know more from you specifically and then go to the guide. But if you go to the guide, you'll see examples to that effect.
Okay. Next question.
I like the guide because it has examples. You can see it. It's not just a bureaucratic document. That's why I like it.
Okay.
I give credit where it's due. It's a good document.
Okay. Next question. A ROD would be done if no contract. Oh, this sounds like maybe more of a comment. Seems you would want your procedures to define receipt and reporting timeframes, including those DFARS defined. Okay.
Agreed. Yeah, that's in one of my slides. Make sure your procedure. One of the presentations I gave at NES 2 years ago is that it all starts with receiving. Everything starts with receiving. The contract property business system starts with receiving. Okay. So receiving's got to be done right.
All right. Next question. Oh, I'm sorry.
And you got to document that. Yeah, go ahead.
I didn't mean to talk over you. When submitting a transfer in PI, how long does it typically take to receive acknowledgement?
That I do not know. Not being a defense contractor, I can't go in PIE and kind of noodle around. So I don't know how long that. I don't know if there's even a delay involved. So I can't answer your question. Okay. There is a help desk in PIE. I know you can ask that question too.
Okay. And there was a follow-up, just the word yes. I think this was Joe's. Hold on, Joe. Let me find your other question. This was in regard to the mod. or the MOD.
Yeah.
He just said yes. So does that make sense to you?
I kind of lost that question. Does
Okay.
what makes sense to me?
Hold on one sec. Let me find it again. If contracts were created prior to
Oh,
January
okay.
22nd, that one, what do you suggest they do? I can't remember what you asked for a
So
follow-up on that.
well, let me answer the question a different way. You're going to have contracts with old clauses and the new clause and old clauses, and that by itself you're going to have to do some housekeeping to update your procedures. The government may want to do. They may want to modify existing contracts to add and delete old clause, new clauses, that kind of thing. I advise clients don't sign up to that too quickly because of the marketing requirement. If it was just a matter of reporting, I think that you could manage that. It's things that about the reporting as I've indicated are a little problematic, but I think you could deal with that. But if you suddenly add the 7005 clause to an existing contract, you've added deliverables into your new contract that you never even considered. You never priced them out. You wouldn't even know where to begin. So if that's the kicker for me, that it would be an issue if you suddenly added those new requirements for marking. If you're a repair company, okay, many contractors just don't do repairs, and that'd be another. It might be a little easier, but if you're doing substantial repair work and all of a sudden you get in these new requirements to mark and create IUIDs for serially managed reparables, it's a whole nother work. That's a whole another mission. You got to get your engineers involved. You got to get QA involved. You got to get. I mean, you can't just willingly accept that. You might be able to do it with consideration, which is another story. I mean, this is complicated stuff. The thing about repair work is the solicitations go out. The government sends in solicitations, and there may be a statement of work or whatever to describe what they want, but in a way, the marking requirement embedded in this clause is over and above whatever they ask you to repair with. They may even know. I think many of the government people are not going to know yet the implications of that marking requirement. It's a whole nother business area, in my opinion. And that's why I say it is not a property management thing. They've embedded a deliverable in a property clause. I would argue it does not belong there, belongs somewhere else. And it's going to create a lot of different kinds of friction between government and industry, in my opinion. And that's why I think the whole issue of the blockchain and modifying existing contracts is going to get very complicated, to say the least. So my recommendation is that don't agree to it if you can avoid it, unless there's some kind of consideration involved.
It looks like from Joe's comment that it's too late. Their CO did agree to it, so they're going to have to.
Yeah. Well, hopefully, I would just say I'll get with Joe. I mean, did they do it unilaterally? Did they do it bilaterally? No, too late.
Ugh. Okay, next question.
Yeah.
Ready for another one?
Sure.
Does property class play a role in the government determination of serial versus non-serially managed determination? And does that determination have any RFNIU implications?
I don't know what RFNIU means, but the first part of the question is, does the government, does classification of the item have anything to do with it? That could be anything. The government, the DoD can designate anything as serially managed in theory. So would they use that particular criteria? Well, they might, but I don't think it's limited to that criteria. If you read that DoD instruction that I put up, it goes through a whole litany of things that that would be involved in making those designations. A lot of that is program manager kinds of things and decisions. So to answer your question, they can identify anything as serially managed if they want. There's
Okay.
no restrictions on it that I can see. I don't think there's any limiting principle on what's serially managed. And that the point of it is, though, if it is, it has to be, and they want something done, they got to identify it as such on the attachment. And don't think something is serially managed because it's got a serial number. It's got to be cited on the attachment. Okay.
Okay. Is that room for equitable adjustment? Is the question, or is there room for equitable adjustment?
Yeah, you can always ask for an equitable adjustment. That doesn't mean you're going to get one. The contractor can be entitled for an EA for lots of different reasons, but the CO is under no obligation to provide it. That's the general principle of EAs. So you make your case and you see how it goes.
Okay.
Was that Joe again?
No, that was someone else.
Okay.
Somebody also noted that reporting within 7 calendar days, which really means 5 days, seems very oppressive, and they were just wondering how was that timeline determined?
Yeah, I don't know how DoD came up with that timeline. Previous clause didn't have a timeline. It just said follow your procedures. I don't like timelines generally in regulations because it's just too strict. So there's nothing, to me, there's nothing magic about 7 days. So I don't know how they came up with that. I just don't. Now I said calendar days because this clause says days. The FAR says calendar days. So you go back to what the FAR says, and it says calendar days. So you got to think about things like, is your receiving shop, is the guy in receiving or the gal in receiving going to be on vacation? That kind of thing. I mean, once you start regulating to that level of detail, you create all kinds of variation. And I know there are ways to automatically report to PIE. Some contractors have done it. I confess I'm not an IT guy, so I don't know what kind of middleware you need to do that, but I know it's been done. But to your point, I don't like the 7-day requirement either.
Okay. Next question. If the GFP attachment is wrong, so we as contractors accept it, and then the follow-up was the GFP attachments being wrong can or will create utilization issues during PMSA. And how do we tell the government their GFP attachment is wrong?
You notify the contracting officer and let them create a contract efficiency report to correct it. That's the answer.
All right, next question. Are they not supposed to ship it in Pi so you get an email saying you have a contractor receiving action?
I think it does have that capability. I don't think I could talk to it specifically. Again, I can't go in PIE and noodle around, but I think it does. The application does have that capability. Yes.
Okay.
Now, does the government on the DoD side, are they on board with that? I think some are, some not. I think there's some inconsistency there, but I think the capability is there.
Okay. Just real quick, Tom, the guide that you mentioned.
Yeah.
Can you repeat what the title of the guide was, or?
It's the DoD line item guidebook guide. That's all it is.
Thank you.
It's easy to find on Google, but if anybody can't find it, just email me. I have it on my desktop. I look at it all the time. It's a good, mind you, this is not what contractors have to do. This is what government has to do. But it's very, very useful, and it's got all the references and examples, and it's the DoD, whoever wrote it, I'd say good job, because they did. It's a good. It ties into FAR Part 4, which is how to make line items, and DFAR 204, which is their line. Good document.
Okay, and
it's
then
good instruction.
Perfect. Someone else suggested also for everyone, the DoD procurement toolbox is a useful site to help folks. So
yes, it is. They have a lot of good information up there to their credit. DoD has always put a lot of effort and time and resources into letting industry at least know their view of how this all works and free training and so forth.
Okay.
So yeah, DoD, it's a good source of information. I agree.
Okay. Another question regarding that 7 days. When reporting receipt, is the 7 days transfer after the contract mod or when property is in custody of the contractor? Please clarify.
Okay, so there's two transactions there. One is receipt and one is the transfer. So for receipt, in my view, since it doesn't specify anything else, you go with what's the reasonable interpretation. You report within 7 days, 7 days after you have created a receiving report. So if you create a receiving report on January 1st, you have to report to the PIE that you did it by January 7th. The transfer activity, which is between contracts, which is a government activity, I would say 7 days from the time the government signs the mod, or if it's bilateral, whoever signs the last. I would say, if you want to get real nerdy here, so it's 7 days from the last signature. That would make the most sense to me. So it's two transactions. You got a receipt action, and then you have transfer between contracts, which now, as I've gone through PIE a little bit, and the procurement toolbox, there's some indication that DoD thinks that GFP module is also a receipt on the new cut. So it gets, again, I don't know why they did that. That's very complicated. But to answer your question, one is a receipt action when the thing comes in the door. And the second one is when contract mods are written to add to GFP to an existing contract or a new contract.
Okay. Another question. When submitting GFP transfer back to the DoD, contractor to DoD in PI, it requires a property shipper code and property receiver code. The property shipper code is usually the cage code, but where do folks get the property receiver code from?
I'm going to have to say you'd have to ask the PIE help desk on that question, because I do not know. Now, these questions are good, and here's sort of the issue here. You have the clause that lays out the framework, how this is supposed to work, but there's a lot of things that you're not going to know unless you really go in and start working the system, and that's why I say talk to your contracting officer, have a plan, and be, explain how this system isn't all perfect yet, and that you don't want to get hit with a non-compliance issue simply because the system is clumsy, if I can put it that way in a non-technical term. So you can't go wrong with asking the help desk, and if you have to, go to the CO and proactively explain these issues that you're having, so you're not on the defensive when you have a PMSA.
Okay. And then there was a comment, this was a follow-up to one of the others. The one where you asked me if it was Joe, and it was not. The question, not necessarily. If they send you an item that is not part of the PWS, then the contractor has a right to reject acceptance.
Oh, that's a tough question, because there's nothing anywhere that says that. I would say if I were writing a procedure for a contractor, and I've been a contractor and I worked in receiving, I would call it a conditional acceptance. Because what does that mean? You have the right to not accept. Well, what are you going to do? Are you going to leave it out in the rain? What are you going to do? You still got to take it, right? What if in the commercial setting, if you got something from Microsoft, or Dell, you ordered a laptop, and and they sent you the wrong one? Would you not accept it, or would you put it aside and work with the vendor to figure out what to do next? So I would not support that non-acceptance concept that you've just mentioned. You just document the fact, you document the discrepancies, et cetera, but you've got to receive it, because that starts the clock running on the whole thing. I mean, you can't just not accept something. And I don't even know how to define that. What does that even mean? You're not going to make a receiving report? How can you do that? You got it. So.
Okay. Next question.
So,
These
are great questions, by the way. Outstanding questions.
Yeah, and they were still coming in.
Please do. I love it.
If there is no GFP attachment, should you still create a receipt report?
Yes. Yes.
Right?
Absolutely.
All
Always
right.
make a receipt report. You cannot go wrong with there's no real good reason not to make a receiving report, in my experience. It will always fall back on you as not doing something.
And then next one, are we supposed to report receipt when assets transfer from one contract to a follow-on contract in PIEE or PI?
Well, that's what the transfer reporting is all about. To answer your question, yes. My issue with that requirement is, why does it even exist? That's a different story. But that's what the clause says you got to do. What you just said is what the clause says you have to do. Because the module considers those transfers as receipts. And that's why I stress defining receipt in your procedure. Now, if DoD in this DFAR clause defined receipt a little more expansively to include that scenario that you just mentioned, I would have no issue with it, other than, okay, you might want to consider why they're doing that, but at least I would understand it. But because they don't define it, that's why my crystal ball says there are going to be issues associated with that problem, with that whole process, because people are going to define it differently. It's inevitable. It's just going to be a lot of variation. Variation causes friction. Friction causes cars, and nothing gets done.
For those contracts with the prior DFARS clause, should the GFP be reported in the PI even if it is after the 7 days?
Could you repeat that, please?
Sure. For those contracts with the prior DFARS clause,
Yes.
should the GFP be reported in PI even if it is after the 7 days?
I'm not following that question, but the 7 days is 7 days from a transaction, and I'm not quite sure what transaction you're referencing there. I think there's a
Maybe Claude.
I think there's two issues there. Yeah.
Okay, maybe Claudine, if you've got follow-up for that, I can read that out to him. I'll read you another
It's
question.
7 days from a transaction. So you got to ask the question: what's the transaction? Well, I shipped it. Okay, that's a transaction. I received it. That's a transaction. So you got to tie that to something, and that's the challenge.
And then here was a comment. They should follow the applicable clauses stated in the current contract unless the government does a mod or block change.
That's correct.
Okay.
And be wary of those. Be wary of those mods. Yes.
All right. And then another question: does reparable mean parts that came in for repair or parts that can be repaired?
That come in for repair. Because things that can be repaired may not be a contract requirement, right? Anything can be repaired. I think the context here is a repair contract.
Okay.
You know, the government sends you a broken toner cartridge. Please fix it. That kind of thing.
Okay.
Now it's something. Yeah. Go ahead.
Sorry, I didn't mean to. The RFNIU that we heard earlier is rent-free, non-interference use.
Oh, okay. I don't think that has any connection to this.
Okay. And then I've had a couple people who've had to leave because they have other things going on, so I will email you those questions.
That's fine.
Let's see what else. Yeah, it looks like okay. Here's one. We should not be completing this form for the customer, but lost the battle. Most of our COs have us completing their GFP attachments when requesting transfers. We put everything on non-serially managed tab. Does that mean it will not be in the mods?
I would not do that. I would not do that.
Okay.
That's my answer. It's not your job. Now,
Okay.
if the government wants the data so they can create an attachment, fine. They can create a contract, a CIDRL to provide the data, and they make the attachment. I would not create attachments under any circumstances. It's not the contractor's job.
Okay. And then another repairable question, are all repairable items considered GFP? If so, okay, so if so, would that mean all repairable items should be on the GFP attachment?
Yes. Yes.
Okay. And then here's Claudine's follow-up. Not because property is on the GFP attachment list does not mean that the contractor received the property. Therefore, reporting receipt prior to taking possession of the property in PI does not make sense. Do you need me to read that? To get that again?
Well, the way the application to PIE is set up, it's set up as if everything is going to go perfectly. That there's going to be an attachment, you're going to receive it, against. I get that, but the application is not perfect, nor is the DoD policy side where people are doing it. On the matter of receipt, I'll say again, receive it. If you can't receive it and the PIE application prevents you from doing it, notify your contracting officer why. But you got to receive it.
Okay.
No matter what. You can't absolve yourself from not receiving something, in my opinion. It will always come back as a contractor problem.
Okay. If the
Yeah.
GFP, this is the same person, if the
Sure.
GFP was not reported prior to the effective date of the new DFARS clause, do you still need to report those contracts in PI even though it is after the 7 days?
Well, I think you're conflating the reporting requirement with the clause. You still, even on the old clauses, you got to report. So you should have been reporting anyway. So I'm not quite following that question.
Okay.
You should have been reporting all along, regardless of this new clause. So that shouldn't have changed.
Okay. So, and then here's a comment. The attachment is an authorization. The balance on hand is dependent on the receipt of property.
Mm-hmm.
Okay. And then if an item is deliverable on DD 250, do you still need to do a GFP receipt, then a GFP shipper to return it to the government?
I think yes, but it's not in GFP module. It's in the other module. It's the water workflow module in PIE that would tie to that question.
Okay. And then
And that goes to, if you saw the slide I made on something it's called Appendix F of the DFAR, which explains how you get paid through water workflow, et cetera, et cetera. So it's a different kind of reporting that would go on for reporting of deliverables.
okay.
Yeah.
And then when you say receiving report, are you referencing completing a receipt in the GFP module, or are you referencing a local facility process?
I'm talking about a local facility process. Something comes in the door, you create a receiver report, or some contractors don't have per se receiver report, but they document the receipt. Remember, the FAR doesn't say anything about receiver report. The FAR says document receipt. Whatever the means, most companies use receiver reports. So you make a receiver report, and then you have 7 days to tell PIE GFP module that you created one. That, to me, is how this is supposed to work. They're two different things. There's the receiving. Remember, the clause is not a receiving clause. The clause is a reporting clause. Meaning you have to report something that already occurred, a prior event. The event is creating the receiving report. Hope maybe that makes better sense at that way.
And then how would you receive something in PI without a GFP attachment? How would you know if it's serially managed or not?
It would be identified as such on the attachment. If the government is not in any way demonstrated or communicated that it's not serially managed, then it's not. It's not your job to check and double check. Now, I know there's an alignment, a technical alignment between attachments and reporting receipt. again, I can't go into PIE and doodle around, but if you have any issue or problem on reporting receipt, go right away to the help desk and try to get that sorted out, because it'll go back to you. You guys didn't do enough, right? You got to, burden of proof is on you to make this all work. And if it's a technical issue that's involved at PIE that you can't fix, then tell your CO, look, I want to do this, but I can't. Here's why. Okay, that's the best advice I can give you, because I know PIE, it's an application, and they're always updating the software and doing fixes, and on any given day it could be different. And even if you can't report to PIE the receipt, at least make the receiving report.
Okay.
Because there's really no way you can get around not making a receiving report. This is, in my opinion, you got to. That's one thing you got to do.
Okay. And
to me, it all starts with receiving.
right. And here's an example, following up with the individual earlier. The government asks the contractor to do the GFP attachment list. Should the contractor request a CLIN to perform this action?
Sure, you can request it. You can make a SIDRL for that. Absolutely, you're reporting data. Why not?
Okay.
Sure.
And then if you
Will
receive,
they do it? I don't know.
sorry, didn't mean to cut you off. If you receive an item before the GFP attachment is uploaded, there will be 2 lines on the line item management. The receipt
Right.
will not match the attachment. Oh, okay. Thanks,
Yep.
Sarah.
Thank you, whoever said that. See, people who use this every day know these little intricacies, and I confess I don't, because I'm not a defense contractor per se. And it's important that you know all those little intricacies. Maybe someday one of our members can do a presentation that really reduces all this to actual practice in PAE. That'd be very helpful.
Well, a couple of quick plugs. We are going to have Carol Brown at the NES.
Oh, very good.
Where she's going to be doing some really practical information, but I was also going to invite and Sarah. I won't say your last name, but if you're going to be at the NES, we still have a few spots available for speakers if you wanted to do something.
Yeah, see, I can give you the big picture stuff, but but into the weeds of PIE, I can't do it because I'm not. I have no mechanism to do it. I can't go into PIE and do stuff.
And I know they have the webinars. I know they have the trainings there, but I know there's a lot of demand. We get a lot of demand for this information, this content. So we would love if any of you feel comfortable sharing your knowledge and are going to be at the NES, we'd love to have you there as a breakout speaker. That is it. Of course, the usual kudos and gratitude is coming in. Everybody appreciates you sharing your knowledge. I hope people will see you, come and see you at the NES.
I'll be there.
We love to have you there. And then just a really quick housekeeping. I have dropped into the email that's going to go out to you in about an hour. There will be a link where if you were not able to access the slide PDF, you should be able to click a link from that email and download the slides. And I think that's it for now. Thank you again, Tom. Thanks for everybody who was here.
Thank you for your patience.
Yeah.
Complicated stuff. I appreciate everybody's patience as I go through this.
Right. And if anybody has any questions, you can email me at conferences@mpma.org, and I will try to follow up as quickly as possible. All right.
Okay.
All right.
Signing off.
Thank you so much.
Bye.
Bye.